Professional responsibility, comments in class on the rules. uh, just beginning with Section 1, Lawyers' Laws and Ethics. Rule 2.1, lawyers may refer to other inputs like moral, religious, economic concerns when advising a client. Preamble, she points us to paragraphs 7, 9, 16, and 19. Moving on to Part 2, the lawyer's duty to protect client information and confidences. There's 3 doctrines. So Doctrine 1, Model Rule 1.6, professional duty of confidentiality, right? So you owe, in Part A, a duty of confidentiality to current clients and former clients and prospective clients unless you get informed consent or another exception in B. We've talked about those, right? The exception in B is 1, to prevent death, serious bodily injury. 2 is to prevent crime or fraud before the crime or fraud occurred. 3, and so keep in mind, you can keep it quiet after the crime fraud's occurred and there's no more injury to be done. But 3, prevent injury or to financial interests from clients' commission of a crime or fraud that has already occurred. So if financial harm is ongoing, you can break duty of confidentiality. So 4, secure legal advice from another lawyer for you to comply with the rules. 5, when a lawyer is defendant in a lawsuit against a former client and this information is relevant to the lawsuit, right? Like if you're sued over the advice you gave for malpractice, that's obviously waived. 6, comply with other law or court order. So comment 4, the word hypothetical gives some room to casually discuss a case in very general terms. And then comment 6, you try to get the client to consent before disclosing to a third party. 1.8b, don't use client info to the disadvantage of the client. Obviously, 1.9c, if you represent a client in a former matter, you can't use that information related to the representation to the disadvantage of the former client or reveal information relating to the representation, right? So moving on to 1.18a and b, a person who consults with a lawyer about the possibility of forming a client-lawyer relationship with respect to a matter is a prospective client. She defines 1.0f for some reason. Knowledge is a defined term to mean actual knowledge. 1.2d, a lawyer shall not counsel a client to engage in crime or fraud, obviously. 3.3, don't comment on it. 4.1b, a lawyer shall not fail to disclose a fact when the lawyer knows failure to disclose will assist with the crime or fraud by a client. So most 1.6b disclosures are discretionary, but this rule draws out that you must disclose a fact when failure to disclose would assist with a crime or fraud. Keep in mind, that's 4.1b. Doctrine 2, attorney-client privilege. Rule 1.13, the organization is a client, so you see Upjohn for that. 3.4f, a lawyer shall not request a person other than a client to refrain from voluntarily giving relevant information to another party unless 1, the person's relative or employee or other agreement of a client, and 2, the lawyer reasonably believes that the person's interest will not be adversely affected by refraining from bringing such information. 1.6, comment 16, she points us to that. So you assert non-frivolous claims of attorney-client privilege if you need to. Moving on to 3, self-regulation of the legal profession. 8.1, so don't lie or fail to disclose material fact to the bar when you're applying for the bar, obviously. 8.4 says it's professional misconduct to 1, violate model rules, 2, commit a criminal act that reflects adversely on the lawyer's honesty, 3, engage in conduct involving dishonesty, fraud, deceit, 4, engage in conduct that is prejudicial to the administration of justice, 5, state or imply the ability to influence improperly a government agency, 6, knowingly assist a judge in professional misconduct, or 7, engage in conduct that the lawyer knows is harassment or discrimination. 1.0d is just the definition of fraud. 8.1, applicant into the bar shall not knowingly lie or fail to disclose a necessary fact. 8.3, there's duty to report other attorneys' misconducts. And 8.4 says professional misconduct to violate rules. B says it's professional misconduct for a lawyer to commit conduct that adversely affects on the lawyer's honesty or trustworthiness. C says it's professional misconduct to lie. D says it's professional misconduct to engage in conduct that's prejudicial to the administration of justice. Comment 1 is reporting even isolated incidents is important. That's what it says in comment 1. Back to 8.3, comment 4, model rule 1.6, duty of confidentiality to your client who happens to be a lawyer getting advice related to misconduct. That trumps 8.3. So, right, remember 1.6b, there's a safe harbor where if you're getting advice on professional misconduct, you can disclose that to a third party. Well, that's going to trump 8.3 that says you have to report misconduct or whatever, right? So if you're a lawyer giving advice on another lawyer's professional misconduct, that's protected. 5.1, responsibility of partners, managers, and supervisors. It's possible for a partner to be responsible for the lawyers under them conduct. 5.2, responsibility of subordinate lawyers, what it outlines. 5.3, responsibility of non-lawyers. 8.3, again, just says you have a duty to report other attorneys' conducts, unless, again, we're talking about the 1.6b exception where you're giving advice to a lawyer client who is trying to get legal advice on their potential misconduct. Moving on to the multi-jurisdictional practice and unauthorized practice of law. This is all, again, still under Section 3, but that's just where we're at. Multi-jurisdictional practice of law, comment 14, a matter involving multiple jurisdictions, including your jurisdiction, may be enough under 5.5c4 for a transaction not to be an unauthorized practice of law. So yeah, if you're doing a deal in Illinois, Illinois client, they're buying a portfolio of real estate, most of which in Illinois, but then also one on property in Wisconsin. That's enough. It's probably related to Illinois. Then 5.5d1 permits in-house lawyers to practice in foreign jurisdictions while keeping your home state license only. That's fine. 8.5, choice of law. 8.5b2, when disciplining a lawyer, use the rules in the jurisdiction where the alleged misconduct occurred. Moving on to Section 4, liability for lawyering activities. 1.1, lawyer's competence, just use a reasonable standard. Comment 1, complexity, lawyer skill, lawyer's experience, preparation the lawyer is able to give to the matter are all relevant factors to consider when deciding whether representation was competent. Comment 2, novice lawyer can take on new types of cases so long as you acquire necessary competence while handling the matter. Comment 4, a lawyer may accept representation where the requisite level of competence can be achieved by reasonable preparation. 1.8h. So this is settling cases before the fact and after the fact. So 1.8h, before the fact. A lawyer shall not make an agreement prospectively limiting the lawyer's liability to a client for malpractice unless the client is independently represented in making the agreement, or after the fact you can settle malpractice, but you must inform your client in writing of the desirability of seeking their independent counsel and give them an opportunity to get independent counsel. That's 1.8. Moving on, 1.2d. A lawyer shall not counsel a client to commit a crime, but a lawyer may make a good faith effort to determine the validity, scope, meaning, or application of a law. Makes sense. Moving on to Part 5. 1.2, we were just talking about a second ago, actually. Comment 5. Legal services shouldn't be denied to someone who can't pay, and representation does not constitute approval of that client's views or activities. 1.18, it's duties to a prospective client. 6.1 says a lawyer should try to provide 50 hours a year of pro bono service, whatever. 6.2, rules and exceptions. Basically, don't avoid appointments by a tribunal except for these exceptions. When 1, the lawyer is incompetent. 2, representing the client is likely to result in unreasonable financial burden on the lawyer. Or 3, the client or the cause is so repugnant that the lawyer is to be likely to that it's going to likely impair the client-lawyer relationship. Comment 1 says the lawyer isn't required to represent someone whose character the lawyer considers repugnant. Now we're moving on. No, we're still in 5. Looking at Rule 1.16, that's mandatory reasons to withdraw. 1.16b is permissive reasons to withdraw. And C is getting substitution of counsel order from the court. We talked about those. 1.2, a lawyer shall abide by a client's decision concerning the objectives of representation. In a criminal case, a client decides whether to plead guilty or not guilty, whether to waive jury trial, and whether a client will testify. 2.1, a lawyer shall exercise independent advice. In rendering advice, a lawyer may refer not only to law, but moral, economic, social, and political factors. 1.5, a lawyer shall not charge an unreasonable fee. You can look to local rules or whatever for deciding what's a reasonable fee. 6, conflicts of interest. We're beginning with 1.7, concurrent conflicts of interest. So there's 2 definitions of when concurrent conflicts exist. Either A, representation is directly adverse to another client, or B, or 2, significant risk that the representation of a client will be materially limited by the lawyer's responsibilities to another client, former client, or the lawyer personally. So B, a lawyer may represent a client if the lawyer reasonably believes the lawyer can provide competent representation. 2, representation is prohibited by law. 3, representation does not involve assertion of one client against another, like on both sides of the B sign, and each client is given informed consent confirmed in writing. Next, we move on to 1.9, conflicts involving former clients. 1.9, you can't represent another person in a matter against a former client unless you get written consent. 1.10, we've read it off. Go to the flow chart. Just looking at the flow chart, you start with does any lawyer L in the firm have an individual conflict of interest under concurrent conflicts or former client conflicts? 1.7, 1.9. If the answer is yes, if the answer is no, any lawyer in the firm may represent C, right? If you don't have a concurrent or a past conflict, obviously there's no conflict. So any lawyer can represent you. So it's easy there. If the answer is yes, you then ask, is the lawyer's conflict based on personal interests of L? If the answer is yes, you're going to move down and ask, does L's personal interest present a significant risk of materially limiting the representation of client by another lawyer of the firm? If the answer is no, does L's conflict is it a 1.9a or 1.9b conflict arising from L's association with a prior law firm? If the answer to that is no, if it's not from a prior law firm, so it's personal interest of the lawyer, not associated with a prior law firm, and the answer to that's no, then the lawyer's conflict is imputed to all lawyers in the firm. If the lawyer's conflict is based on a personal conflict, or it's not based on it's not based on a personal conflict, and it is based on a 1.9, 1.b past conflict with a past law firm, if that's the answer, and L has been screened under 1.10a to 1 through 3, if that happens, other lawyers may represent the client without getting client consent. However, L needs to get consent to work on the matter. If the answer to that is no, if the lawyer hasn't been screened, then L's conflict is imputed to all lawyers in the firm. So going back up the tree, if L's conflict is based on a personal conflict of interest, if it is, the next ask, does L's personal interest present a significant risk of material limiting representation of C by other lawyers in the firm? Limiting the representation of C by other lawyers in the firm. If the answer to that is yes, L's conflict material limiting the representation of C by other lawyers. If the answer to that is yes, L's conflict is imputed to all lawyers in the firm. If the answer is no, other lawyers may represent C without getting client consent. However, L needs to get consent to work on the matter.